Are we live? Hi, everybody. Welcome to the Howard Jarvis Taxpayers Association Taxpayer webinar for June 2023. We're delighted to be here. Apologies for the tech trouble at the top. We have a great update for you today on everything that's going on for taxpayers. My name is Susan Shelley. I'm the Vice President of Communications for the Howard Jarvis Taxpayers Association. And I'm very pleased to introduce the President of the Howard Jarvis Taxpayers Association, John Kupal. John?
Hi, Susan. Thank you very much. And thanks to everyone for joining here. This is a quarterly update of the goings-on of the Howard Jarvis Taxpayers Association. And we have a number of things to talk about. We're going to hear about some legislation from our legislative director, Scott Kaufman. We're going to hear from our legal director on the lawsuits that we're engaged in. But I think one of the first things our members and supporters want to know is, are we going to lose Proposition 13? The answer is no. The Howard Jarvis Taxpayers Association has for 45 years successfully defended against all attacks on the Howard Jarvis on Proposition 13, and we intend to do that for as long as we're in existence. And we could only do that with your support. After this webinar or during, you're always free to go to our website at HJTA.org. We have a wealth of information about everything we're doing on that particular website. For a lot of people who don't really know about the mechanics of Proposition 13, it was passed in 1978. It limited taxes to 1%, and increases in taxable value could only go up to 2% per year. So, and there are a lot of voter approval requirements contained in it as well. A lot of you already know this, but for people who don't know the mechanics and how Proposition 13 helps them, please go to our website. It has saved California homeowners and property owners close to $1 trillion since 1978. So it has been very effective property tax relief. I'm going to save one of our latest efforts, repealing the death tax, for Susan, but I wanted to talk about another initiative that has already qualified for the November 2024 ballot, and that is the Taxpayer Protection and Government Accountability Act. Again, this measure has already qualified for the November 2024 ballot. We collected signatures last year in conjunction with our partners in the business community, and it is critically important that we pass this. What's the problem? Why are we doing this? First of all, we all know that the cost of living in California is a crisis. Prices are out of control. Housing is out of control. A lot of people are just living paycheck to paycheck. And on top of that, California has the highest in the nation effective poverty rate. We have homelessness, crime, and exodus out of the state of California. There are news stories about that every day. A lot of it's driven by bad policies, but also among those bad policies, of course, is our high tax burden. California has the highest income tax rate in America, 13.3%. We have the highest state sales tax rate in America. We have the highest gas tax, and even with Prop 13, we rank 14th out of 50 states in per capita property tax collections. So California has a wealth of problems. And in response to these problems, we believe we can correct many of these problems through the passage of the Taxpayer Protection Act. First of all, it has 4 elements. And one of the elements we know, because we've done polling on this, is extremely popular with taxpayers in the state of California. We know that taxes increases at the local level are restricted to those things that are passed by property owners and voters. But at the state level, it requires a 2/3 vote of each house to pass a statewide tax increase. Now, for many years, in fact, for most of the years of Proposition 13's existence, that wasn't too much of a problem because the legislature wasn't as progressive as it is now. So now taxes do secure that 2/3 vote, supermajority in both houses. So one of the provisions of the Taxpayer Protection Act that, again, is so popular, it says this: even if a tax is passed by the legislature with the requisite 2/3 vote of each house, that tax still must be ratified by the voters of the state of California at the next general statewide election. That is huge. That's going to be hugely popular. And let me tell you the ramifications of that provision. We all know that we suffered a huge tax increase on our gasoline purchases. That is a tax that did pass with a 2/3 vote of each house. But does anybody believe that that tax would have been approved by the voters of the state of California? The answer is no. So voter approval of a statewide vote of any tax increases emanating from the California legislature, that's a very big deal. Another provision that is very near and dear to our heart is closing what we call the upland loophole. And Laura Dougherty, our legal director, will be talking about that in a little bit. But that is a case that threw out the 2/3 vote for local special tax increases and said that if a tax is put on the ballot by a citizens committee, however that's defined, it can avoid the 2/3 vote for special tax increases. So our initiative would close that loophole and, in fact, reach back and affect all of those upland taxes that were enacted after January 1st, 2022. That's a big deal to us, big deal for our lawyers, big deal for a lot of property owners in the state of California. Another provision we have is we prohibit hidden taxes. Hidden taxes can be anything. It can be these little fees and charges that they tack on to all kinds of things. So one of the provisions of the Taxpayer Protection Act is to make sure that any fee, any true fee that you pay is limited to the cost of the service or the benefit being provided to you. For example, if you go to a county park and pay an entrance fee, we don't dispute that. That is a fee that generally represents the cost of the service that's being provided to you. So we tighten the definition, or what we call the nexus, the connection between the fee payer and the service or regulation being provided. We've tried this before, and these cost of service principles are already reflected in many of the initiatives we've already done, so we're just tightening that up. And finally, we increase transparency requirements for tax increases. One of the things that you folks have complained to us about is, hey, we didn't know what we were voting on because it never said that this was a tax increase. So one of the provisions of the Taxpayer Protection Act that we put in this provision is that if something raises a tax or a fee, it has to say so in the ballot label, not hidden in some obscure document. So we have ballot transparency, we have voter approval requirements. This will be a constitutional amendment. Again, the Howard Jarvis Taxpayers Association has done this many times before. We started with Proposition 13, but we've had to come back in 1986, 1996, and 2006 to close these loopholes. And again, government creates new loopholes. So this is an ongoing fight, and it's a fight that, again, thanks to your help, your support, that we are able to continue 45 days after the passage of Proposition 13. And with that, I will turn it back to Susan. Susan?
Well, thank you, John. Thank you for that important update. We are so excited that the Taxpayer Protection Act will be on the November 2024 ballot. Mark it down. This is a really important taxpayer protection. And the other thing that we're working on for the November 2024 ballot is the Repeal the Death Tax Act. As you probably know, you probably helped us collect signatures for this last year. We didn't collect enough to get on the ballot. So this year we are going to try again. We have filed a new initiative. We filed it last week. It is currently at the Attorney General's office awaiting title and summary. And as soon as we get the title and summary, we can print that on our petitions, and you will be able to download a legal petition. It only is one page, one 8.5 by 11 page. You'll be able to print it on your own printer at home or anywhere else at your office. You'll be able to print as many copies as you want. Those will be legal petitions. Once you sign it and you fill out the declaration of circulator at the bottom, and the same person can be the circulator and the signer, each petition will have room for 2 signatures. You download it, you print it, you sign it with a pen, you send it to us. We'll also have drop-off locations, and maybe we'll even come and pick it up if it's convenient for you. We have to collect more than 1 million signatures to make sure we have enough. And we think that with this speeding up the amount of time that it takes to distribute it, we will be able to do this very, very well. And we're excited about it. We're excited about the possibilities that this opens up for grassroots politics. So the content of the measure puts back Proposition 58 and Proposition 193. It restores them the way they were. These are the measures. Proposition 58 was the one that passed in 1986 with 76% of the vote, and it created the parent-child transfer exclusion from reassessment when your property is transferred. So once again, parents will be able to transfer a home of any value plus up to $1 million of assessed value, the taxable value on your tax bill, up to $1 million of assessed value of other property, plus the home of any value to their children, and the tax bill will stay the same. Because under Proposition 19, it's all reassessed to market value, and the new tax bill is 1% of the current market value at the time of transfer. And that is devastating, people. And even though there's an exception to an extent, a limited exception, for a child who moves into the parent's principal residence and makes it their principal residence, it only gives you a partial exclusion from reassessment. You could still get a huge tax increase. We're going to reverse that. We're putting back the old rules. So a parent-child transfer and also a grandparent-grandchild transfer in the event that the children's parents are deceased. So that was Prop 193, which passed in 1996. We are going to put those back. It will be retroactive in the sense that you will be able to get your old Prop 13 value back if you were reassessed for a parent-child transfer. We can't get you a refund on any taxes that you paid in the interim, because at the time you paid them, that was the law, that was legal, but we are going to reverse it, and we are going to have a process whereby you can claim your old, it's called the trended base year value. The base year based on your original purchase price plus the 2% a year that it goes up with inflation, you will get that valuation back. So we're very excited about this. We think that this is going to be, once we get this qualified, we think it will pass very easily on the November 2024 ballot, and we will be happy to answer your questions about it. You can go to repealthedeathtax.com, repealthedeathtax.com, and get all the information on it. You can read the measure. It's very important, you can submit a public comment on the Attorney General's website. You will see that on our website in the menus, that you'll be able to submit a public comment about the initiative. Tell your own story about why this measure is so important to you and why Proposition 19 has harmed your family and you want this fixed. If you submit a public comment that will go to the Attorney General, that might help us explain to the Attorney General why this measure is so important to families all across California. So that's our action item for today. Signature collection will not begin until after we get the title and summary, which is around August 21st. So mark a calendar for that. That's when we'll have the petitions available to sign. And with that, I want to let you know that you can ask your questions in the comments on this or any other subject. Just type it into the comments if you're on YouTube or Facebook. Just type that in and we will see them, and we will try to answer all your questions. Right now, I'm going to turn it over to our great Director of Legal Affairs, Laura Doherty.
Thanks, Susan. Hi, everyone. I'm Laura. I am the Director of Legal Affairs. That means I work with the Howard Jarvis Taxpayers Foundation. So if you've ever wondered what's the difference between the foundation and the association, the foundation is the legal side. We do all the legal work. And we are very busy defending Prop 13, very busy. So as a brief segue from what Susan was talking about with repeal the death tax, I just want to address a couple of common questions we still see a lot of under Prop 19. I mean, we're still living under the regime of Prop 19 right now, and we know a lot of people are having these troubles, and definitely encourage you to submit those stories in the comments, like Susan said. Common question, well, we don't have any legal cases on Prop 19. Sometimes people do ask us, well, can't we sue? Let's file a lawsuit because they lied to us. No, we can't do that. So the ballot initiative is the way to go. That's the way to fix it. So please sign the petition and please provide your support as you can. Our other big piece of legal advice for you, if you're having any problems, is hire an estate planner. It's very important to see an estate planner. They will know the best thing to do for you. And you want someone who is at least familiar with Prop 13 and Prop 19 as it is. If you need information, if you have specific questions, the BOE has a very helpful website with lots and lots of information and answers. You can go there, and if you can't find an answer, give us a call. I mean, we're here to answer questions, but we can't do estate planning, that's all. So, another big question we get is, what if I have a trust? Doesn't that help? Well, it's very helpful, but it does not save you from Prop 19. So keep that in mind. Please see an estate planner if you need to. We really encourage that. Okay, so what is happening in the courts? Let me give you some information on what's going on lately. One thing that's really big right now is vacancy. There are vacancy taxes and there are vacancy fees, and this is getting really popular across the state because, well, as far as taxes go, it's kind of easy to get those passed. Most voters aren't going to pay them. And there's this association between vacant lots and buildings and units and owners and various evils. Now, I personally think it's the fallacy of guilt by association. But policy aside, these new taxes and fees are raising a lot of important legal questions. They're federal constitutional questions and state. And of course, our primary concern state-wise is Proposition 218. Before I tell you a little bit about our case, I just want to mention that if you are concerned about vacancy taxes, a case to watch right now is the case over San Francisco Measure M. That is a vacancy tax. It is also a special tax, which could be affected by that Taxpayer Protection Act that John was talking about. But the main question in that case is federal and state constitutional rights. Can a vacancy tax even be constitutionally imposed on anyone? And that's a question because we have a basic right to exclude others. That's one of our basic property rights under federal law. So if we're being required to rent out a unit, no matter how hard it may be, or to build something, no matter how hard it may be to get through all the red tape of building something, is that a violation of our constitutional rights? And we would agree that it is. So that's a very interesting case. It's not our case, but I wanted to mention it, the case of San Francisco Measure M. Feel free to look that one up if you are concerned about the expansion of vacancy taxes. Now, our case that we are litigating is over a vacant lot fee, and it is called Howard Jarvis Taxpayers Association versus the City of Long Beach. And the plaintiffs are actually our association and a gentleman in Long Beach who owns a vacant lot. He keeps it perfectly clean. He's just hoping that he can build something for his family someday, or that someone in his family might build. It's hard to stay together in this state. We all know how expensive and difficult it is. So he owns a vacant lot, and the City of Long Beach is now charging him $780 a year as a vacant lot monitoring fee. The City of Long Beach did not go through the Prop 218 process. It really should have. That's a property-related fee. It's a classic property-related fee. The city is arguing, we're not charging him because he's a property owner. We're charging him because he's making an unusual choice to keep his property vacant. This is one of those loopholes. So John mentioned there's loopholes that the government tries to make in Prop 13 and Prop 218. Well, when they happen, they come to us and we take them to court and see if we can get them fixed there. And if not, then they've got to get fixed later. But I'll go through Prop 218 a little bit here because this is a very important case. As most of you know, it was passed in 1996 to stop governments from getting around 13. Governments were adding on to charges for utilities, assessments, anything to do with your property. But Prop 218 said that every charge has to be based on cost of service, and property owners have rights to participate. And through a majority protest, they can defeat a fee, such as this vacant lot monitoring fee. And in fact, what they should be doing, because this isn't one of your regular fees like water, sewer, and garbage, is they should be getting approval of all of the vacant lot owners. They should be getting approval of a majority of them, actually. They could also put it on the ballot for a 2/3 vote. So, the point is the city of Long Beach has options to get this fee passed and approved if it's a really good idea. But they're not supposed to do it without the consent of the property owners or 2/3 of the electorate. That is how we enforce Proposition 13. So unfortunately, we had our hearing last week, and then we got a negative decision, but it is only temporary because it's just the trial court. In fact, the judge, being very cordial and professional, said he knows he is not the final decider. So the Court of Appeal will make this decision in the end. We're very confident that we have a good chance on appeal. The judge based his decision on some language from a 2004 case that was out of context. But if you look directly at Proposition 218, it is very clear and very strong that property owners have these rights. So over the next couple of years, sometime in the next couple of years, we can expect a decision from the Second District Court of Appeal on the question of whether a city or county can avoid Prop 218 by essentially labeling a property-related fee something else. Will they get away with this loophole? We'll know that in a couple of years once the Court of Appeal gets a decision on this. Also in Los Angeles, a very big case is our case against Measure ULA. A lot of you, I'm sure, are familiar with this, but I'll give you a quick rundown of it first as well. This is a Proposition 13 case. Measure ULA has been known and marketed as the mansion tax. So of course, that makes it sound like it only applies to very wealthy people, but it does apply to all real estate. So that includes apartment buildings, commercial buildings, everything. And even if you don't own a home or a larger building of that value right now, you want to watch this case because it could be, if it becomes a bad precedent, it's going to open the floodgates of collecting that value of savings that everyone has on Prop 13. So what happened in the case? Well, we filed it in December after Measure ULA ostensibly passed. Measure ULA is an initiative ordinance, and it taxes all sales and transfers of property over $5 million at very high rates. If you sell a building or transfer title in the value of over $5 million, there will be a tax of 4% on the transfer. And it doesn't matter if there's any mortgages or other liens. There's a tax of 4% on that amount. If it's over 10 million, the tax goes up to 5.5%. So the type of tax here is really important. This is a transfer tax. Proposition 13 banned transfer taxes specifically because that would be one way to get around the savings that you have under Proposition 13. It's the government's way of saying, or it would be the government's way of saying, well, you saved all this money. Now that you're selling your house, pay up and we'll take everything that you thought you saved. So there've been a lot of court cases over transfer taxes, but they kind of plateaued in the 1990s. And the result of all the court cases was this. Charter cities are allowed to have transfer taxes, but only general fund transfer taxes. No one is allowed to have a special transfer tax. And that's what Measure ULA is. It is a special transfer tax. And it's special because everything is being dedicated to certain purposes, housing and homeless solutions. So it's been known all this time that you cannot have a special transfer tax. No one's tried it. until the upland loophole started unraveling things. And that's something John mentioned. In 2017, the Supreme Court came out with a decision that actually had nothing to do with transfer taxes. But there was certain language in it about the initiative power that got a lot of people thinking that if we propose legislation as an initiative, well, then we can do anything. And the first thing that was happening is they were reducing the voter approval threshold on special taxes from 2/3 back down to simple majority. So in one case there was a politician in San Francisco who had a special tax for childcare, and they knew they didn't have 2/3 support. So they took the text and copied it onto an initiative petition, ran it through, got 51% approval, and it passed, and the court said, okay. So the upland loophole started out as this trend of saying, well, if we just turn this special tax proposal into an initiative, then we don't have to get the 2/3 vote anymore. And there's been a lot of activity there with the lowering of the 2/3 voter approval threshold. But how it relates to Measure ULA is that the proponents of this measure are testing further waters. They're saying, we know that under Prop 13, we're not allowed to have a special transfer tax, but we propose this as an initiative. So we're going to try. It got simple majority. It was declared passed. December, we filed our lawsuit to invalidate it. Another party a couple months later filed a lawsuit to invalidate it as well based on other legal theories. So then we had 2 cases. And we've gone through some procedural hurdles. The last time we were here together, the case was kind of in limbo procedurally. So those procedures have kind of come and gone since. Here's the update. The 2 cases have been related and consolidated, which just means that they're being heard together in the same court. And there will be one judgment regarding Measure ULA. So we won't have one judge saying it's valid and one judge saying it's invalid and then wondering what to do. So that's just for clarity's sake, right? We also had our first judge leave the department, and there hasn't been a new assignment just yet. So we've had 2 temporary judges sitting on procedural hearings. And several parties, meanwhile, have agreed on a schedule, and one of the temporary judges did agree to our schedule. So the good news I have is that we have a hearing date. We have been working and working and working to get an actual hearing date. And that date now is September 26th. That is a merits hearing. We should actually have a decision from the trial judge shortly after September 26th when they take it under submission. Now, again, just like in the vacant lot fee case, win or lose, this case will go up on appeal. So be looking for news September 26th forward. But just know that it will go up on appeal either way as well. Now, if you are affected by the Measure ULA tax, an important thing to know is to file a claim within 1 year of paying it. And we do have instructions on our website if you need those. So just go to our website, it's on the front page. And remember that if you're not affected now, you might be affected later. Again, this measure is just testing the waters, seeing what can be done. We don't want to see this happen. We don't want to see other cities and counties copy the technique. That's what we're working to prevent as we protect Prop 13. Now, we do have another case protecting Prop 13 right now as well. Our chief counsel, Timothy Biddle, is litigating a case over the Delta Tunnel. I'm sure everyone remembers it used to be the twin tunnels, and then that got changed. It's just one tunnel now. The plan is for the tunnel to carry water from the Bay Delta and the Sacramento River and take it south to the Central Valley in Los Angeles. So this is a huge project. We're talking $16 billion in bonds being at issue. So in this case, it started out just very appropriately. The Department of Water Resources filed what's called a validation action. This is very common. Government agencies sometimes need to go to court, especially if there are bonds at issue. They go to court, they try to put everything in their complaint, asking for validation, saying, please, judge, tell us that everything we're doing is okay, so that the bond investors don't have to worry. Everything will go forward and not be subject to future litigation. But HJTA saw this complaint and had a couple of concerns. One concern is that under a part of the Constitution that predates Prop 13, there is supposed to be voter approval of any debt over $300,000. The voters are supposed to have a right to approve. Now, if there's enough revenue to pay the bonds, then that's one thing. But in the event that there isn't, we want it to be clear in the courts that the voters have a right to approve this debt. Now, specific to Prop 13, we have our second concern, and that is that we don't want to see the payments necessary for these bonds going on your property tax bill as an override. And that is something that was not clear in the complaint either. So our chief counsel is litigating this case. What we did is we filed an answer to the validation action to become a party. There are so many parties in this case. Sierra Club, everybody's involved with all sorts of different issues. But the judge actually took special interest in the Prop 13 issue, asked for supplemental briefing on it. So we hope that the judge is taking it very seriously. And that's fully briefed now, and we wait. We wait for that decision. Lastly, I want to share with you how the foundation has been participating in some United States Supreme Court cases this year. There are 2 cases we participated in. We participated as amicus, so that means we're not representing parties to the case, but there are issues that are important enough to us that sometimes the parties in the case will reach out to Howard Jarvis and say, would you please file an amicus brief in this case? So we've done that, and one of them has great news and one of them has unfortunate news. The one that made it in and turned into a victory for homeowners nationwide is called Tyler v. Hennepin. It's a case in Minnesota, and this is on the issue of home equity theft, which you're going to hear about, I believe, more from Scott when we get to the legislative side of things. He's been working on it in the legislature, and we think maybe they will listen a little bit more now that the Tyler v. Hennepin decision has happened. What home equity theft is it's basically a form of government exploitation that about 20 states, I believe, are engaging in to various degrees. What happened in this case is a woman named Geraldine Tyler. She's an elderly woman who needed to move out of her home. She needed to move into an apartment in an area that was safer. Her neighborhood was not being so safe anymore. She needed to go, and she got behind on her taxes. She owed about $2,300 and it ballooned into $15,000 by the time the penalties and interest went on there. And then she couldn't handle that. So it turned into a tax foreclosure. Well, at the foreclosure sale, the highest bid was $40,000. But the county of the Hennepin County kept the $25,000 extra. It just kept it. And even the state of Minnesota backed them up, saying, well, title goes to the state when you let your property get foreclosed on. So this went all the way up to the United States Supreme Court. And just recently, a couple months ago, the Supreme Court said in a 9-0 decision, that is a classic taking. That $25,000 belongs to her. They went back to the Magna Carta and they said, no. So now states across the country are are figuring out what to do, you know. So as advocates for homeowners, when we heard about this case and we were asked as amicus to participate, you know, we said, yes, because this is terrible. So we did so, and we explained California's version of the problem, which I think I'll leave to Scott, because I think he's got that. California does have its own version. It's very interesting. So the other case we participated in at the United States Supreme Court was a case about the initiative power. It is called Mobilize the Message versus Bonta. And unfortunately, the Supreme Court just denied certiorari, meaning it's not going to hear the case. And so we are left with a negative decision from the Ninth Circuit. And this case goes back to, if you remember, Assembly Bill 5 from 2019. That was legislation redefining an employee here in California. So we think of it typically as, you know, the case over truck drivers and Uber drivers, Lyft, DoorDash, all that. But it also redefined signature gathering. So there's this great hypocrisy in what happened in AB 5, and this case tried to expose it and get it turned around. The hypocrisy was this: door-to-door salespeople under AB 5 remain independent contractors, but signature gatherers are employees. Now, the only difference between these activities is the content of the speech. So it's a First Amendment violation. And what happens to direct democracy? Well, the cost of signature gathering goes way up. So it used to be $1 or $3 per signature. Now it's about 10. It's about $10 a signature now. So this is really disheartening that the Supreme Court wouldn't hear this. We're very disappointed. You know, this is the functioning of direct democracy here, and petitioning gathering companies have left the state. So it's more of the exodus is happening. Now it looks like only wealthy and powerful groups might be able to run initiatives, and that's not what direct democracy was supposed to be. So again, please participate in the Repeal the Death Tax initiative. We need that support. That's a little bit of what's happening in the foundation. Stay tuned for updates. Thank you very much. And you know, please watch the website for updates. We'll be there.
Only wealthy and powerful special interests and the Howard Jarvis Taxpayers Association. We can do initiatives.
We can do it. We can still do it, but
we can still do it. Well, we have a way. We have a will. We have a way. And thank you all for watching, and thank you all for being part of this important effort. Let me jump in with just quick answers to some of the questions. You can contact us by email, info@hjta.org. You can contact me directly, Susan@hjta.org. I saw that question. With regard to the 25% signature requirement, we're required to tell the state of California when we reach 25% of the required signatures. It doesn't affect at that moment whether it gets on the ballot or anything else, but we just have to announce it to the state of California. Why only 2 signatures per page per petition? We want this to fit on an 8.5 by 11 piece of paper without any shrinking by your printer, because if your printer shrinks it, it won't be valid. Will there be longer petitions for people who are tabling? Perhaps. We haven't made that decision yet. Do we have a list of trusted estate lawyers? I think we have a list of trusted tax lawyers. Laura, do we have a list of estate lawyers we can refer people to?
There are a couple of estate planners on our one list. We have one list of recommended attorneys.
Okay.
So always call your local bar association and ask as well.
Okay, you can email me and I will send you what we have on that if you have that question. And then to segue to our legislation, and from our TPA initiative, we had a question. There's talk in Sacramento of a tax on gun and ammo purchases being discussed right now. Would that have to go on the ballot if the Taxpayer Protection Act passes? Scott, John?
Yeah, I think it would, because there is a reach back provision, so that would have to, I think, have to go on the ballot. But it is our hope that that tax does not pass, and it does have very significant Second Amendment issues because the U.S. Supreme Court has made it pretty clear that these incidental interferences with the right to possess firearms, you can't implement ticky-tack laws and taxes that you don't apply on other goods. For example, if there's a 8% sales tax on all goods in your county, then it is appropriate to pay that tax on a firearm. But singling out an item that is protected under the U.S. Constitution is more than likely unconstitutional. One of the cases that our general counsel is handling has to do with the San Jose gun fee tax. That case is in litigation. Our involvement in that case has to do with the attempt by the city of San Jose to delegate out how the money is spent to a private organization. So we think it fails on the delegation theory, but we watch those cases very carefully.
Okay, so thank you, John, and thank you, Laura. And now I'm going to introduce our legislative director, our fearsome lobbyist who fights for you in the Capitol hallways, Scott Kaufman.
Thanks, Susan. And to answer one question I think you missed, someone asked if it's a petition double-sided or one-sided. It's one-sided, single-sided, for the record. And the bill that you're talking about with the excise tax on ammunition and firearms is AB 28. We are on record in opposition to that. They brought that forward last year, and we stopped it in the legislature. And we're hoping to do the same again this year. There's a lot of folks against it, so we're hoping that there's enough folks against it, and just the fact that it seems rather unconstitutional will stop them. But things being unconstitutional doesn't stop the legislature. As Laura noted, one thing we're working on is the issue of home equity theft, and the fact that in certain instances in California, they can take your home for tax debt. Sometimes it can be a very small amount, and then give you nothing back in return. Here it's if a government entity or a nonprofit working with a government entity for the purpose of low-income housing. If they want it, they can take it, pay the tax debt, and not return any proceeds to you. We think that's unconstitutional. We've told them for 2 years in a row that we think that's unconstitutional. They said, prove it. The Supreme Court has proven it, and now we'll see what they say when we bring it back again next year. Other than that, I'll try to be really brief because I know there's questions. There's probably going to be more questions, and we're coming up on our 1 hour mark, and we started a little late. So I'll be really brief. There's really 3 big bills that we're looking at. Obviously, SJTA 4 was our attempt to repeal the death tax in the legislature. Unfortunately, that failed. It was granted reconsideration, which is just kind of a courtesy thing they do in the legislature, so it's not technically dead. Senator Ciarto told us he's going to keep working it on his end, but he also gave us his blessing to move forward with our ballot initiative because he just wants to see the repeal on the ballot one way or the other. Another one we're looking at, obviously, is ACA 1. Anyone who's watched this or gets any of our emails knows that ACA 1 is a perennial attack on Prop 13. It's an attempt to lower the 2/3 vote requirement for special taxes for the purposes of public infrastructure. And obviously public infrastructure, as we know, that definition has become so broad, it means just about anything. So they're looking to gut the 2/3 vote requirement for special taxes there. We're going to fight that. We fight it year after year after year. We beat it back. That doesn't mean we can rest on it. It's moving this year, so we're going to try and fight it again. The other one is ACA 11, which is actually going to be heard, I believe, on Monday. That's an attempt to abolish the voter elected Board of Equalization. They're kind of like the Supreme Court for property taxes. Not only do they hear cases from taxpayers who think that they're being taxed too much, that their property taxes are incorrect, and they're being taxed more than they should be, but they also interpret the law when it comes to property taxes. They interpret new law and send those letter interpretations as guidance letters to the assessors to implement property tax law. If the BOE goes away, unelected bureaucrats at the California Department of Tax and Fee Administration, it's a mouthful, would take over, and they are not the taxpayers' friends. So we're watching that, and we're probably going to send you an email tomorrow, I think, asking you to call the committee and tell them to vote no on ACA 11 because we think that's a real bad one. Other than that, I see we've got like 3 minutes. but I went as fast as I could. So I think I'm done. And if there's more questions, feel free to ask them.
Well, I want to make sure that everybody knows where to find us. We're at hjta.org. That's our main website. The information for the Repeal the Death Tax initiative is at repealthedeathtax.com, repealthedeathtax.com. You can also visit righttovoteontaxes.com, right, R-I-G-H-T, righttovoteontaxes.com. And there you'll find information about the Taxpayer Protection Act. Don't forget to listen to our podcast. You can find that on our website. It's also broadcast as a radio show every Monday night at 8 p.m. on KABC, which is 790 in Los Angeles, and streaming online from anywhere, kabc.com. So you can hear us talk about the latest news on taxes, the latest news on politics, everything that's going on in California that's going to affect you. We want to give you early warning on it because sometimes you find out and it's too late. So if you want to find out before it's too late, be a member of this great organization. Get our newsletter 3 times a year, Taxing Times, our little newspaper, lots of exclusive content in there for taxpayers. We're just totally focused on protecting taxpayers. It's the only thing we do. Be a member of this great organization. Join online at hjta.org. Do we have any more questions? We answered all your questions. Well, this is recorded. This will be on our website at taxpayerwebinar.com. You'll be able to access this tape and or recording, I guess I should say, and you'll be able to watch it or send it to friends. And we will keep updating you by email. We'll keep letting you know what's going on. If you haven't already signed up for our email alerts, please do. hjta.org is where you can do that. And John, I'll turn it over to you for some final comments.
Well, thank you very much. I only have one comment, and that has to do with the ULA case that Laura talked about. That case is very important. You know, they call that a mansion tax because the dollar amount at which it kicks in seems very, very high. So there might be people out there who say, well, I'm never going to have a real estate transaction of $5 million. Couple points. Number one, they call it a mansion tax, but that effectively affects every commercial property because most commercial properties in Los Angeles are worth more than $5 million. And that includes apartments as well. So anytime there are an increase in taxes on apartments, even like 4 units of apartments, that's going to have a direct impact on tenants and also the owners of those small unit apartments. But the other thing is, if we don't stop this, this is a template going forward. The threshold on this one is $5 million, but we've seen over and over and over again how once they get their clause in a particular tax, they pursue it. Remember that the original income tax in the United States of America was 1% and only affected a handful of people. But over time, that tax grew into the behemoth that we now know it is. So we try to stop these illegal taxes at the very beginning. So that ULA case is something that is very important to a lot of people, and we can correct this. We can correct it with the Taxpayer Protection Act, and we can restore the ability of parents and grandparents to convey property to their kids and grandkids by passing the repeal the death tax, our second big effort. And want to thank everybody. Susan does a fantastic job putting these together, and she's the real talent on our podcast. And I'm just there for show. But thank you again. I have to reiterate, thank you all. The Howard Jarvis Taxpayers Association takes zero government money. So our entire existence and our fight to preserve Prop 13 is only because of your involvement, your advocacy, and your support. So we thank you very much. And with that, I'll say good night. Take care, everyone.
Good night. Thank you for joining us.